We are asking John Ye with Burke, Williams, and Sorenson to come forward and to walk you through the key violations that are the basis for the notice of intent. We're prepared to answer, thereafter we're prepared to answer any additional questions that you have. Thank you.
Thank you, Ms. Miner. You will recall that in September, the board approved in open session the notice of violation, which contained a number of violations against AIMS schools. The primary violation involves conflict of interest violations in the forms of contracts entered in between AIMS and companies that were owned by the founder and or his spouse. These contracts included construction contracts, leases for the use of the AIMS school sites, after-school and summer programs, and contracts for administrative services. Under these contracts, the founder and the spouse personally profited in the sum of approximately $3.8 million. In its response, AIMS admits the existence of these contracts, but denies that they violated the law. The proposed notice of intent to revoke is based on AIMS's response, which incorrectly characterizes and applies the conflict of interest law. AIMS provides a number of justifications for the contracts, none of which provide a legal justification for the violations of conflict of interest law. One noteworthy example falls in the area of the leases between AIMS and the founder's companies for the school sites. One of AIMS's primary defenses to the notice of violations was that under these contracts with the founders, AIMS actually achieved savings of public taxpayer dollars by achieving better terms than the school would have obtained elsewhere from other third parties. However, AIMS committed a fundamental error in one of its examples. When comparing the per square foot rate paid by charter schools occupying Oakland Unified facilities to the per square foot rate paid by AIMS, AIMS actually uses the per square foot rate and miscalculates it as a monthly rate when it's in fact an annual rate. The following slide demonstrates the magnitude of the effect that this miscalculation had on AIMS's defense. AIMS claims that over a one-year period, it saved somewhere approximately $1.1 million in public funds by entering leases with the founder instead of other sources, and over a two-year period, saved approximately $2.2 million in public education funds. However, those calculations are based on the erroneous use of the district square footage rate as a monthly rate as opposed to an annual rate. When applying the correct district rate as an annual rate as opposed to a monthly rate, in fact, annually, AIMS is paying to the director, to its founder, approximately $688,000 more than it would be paying a Oakland Unified charter school occupying Oakland Unified facilities of the same square footage, and over a two-year period is paying approximately $1.3 million more than a Oakland Unified School District charter school occupying district facilities. The notice of intent to revoke is based on a number of findings with respect to AIMS's response. The district found that the AIMS board allowed the founder to personally profit by violating conflict of interest laws. AIMS's response provides no legal or factual justification for those transactions which violated the law. The AIMS response does not acknowledge wrongdoing, but attempts to justify those contracts. And AIMS's response provides insufficient evidence that the governance or financial oversight of the organization has meaningfully improved. The notice of violation that is proposed and brought to you before you tonight contains an evaluation of AIMS's proposed remedies. The primary findings on which the notice of intent to revoke is based are that AIMS presents the same two-page conflict of interest policy that existed prior to the board's issuance of the notice of violation. The only new documentation related to the issue of conflict of interest is a one-page conflict of interest disclosure form. AIMS does have a revised fiscal policy with a new fiscal administrator and a three-person financial specialist committee. However, those individuals have experience that is weighted more in the private sector and not in the very unique and specialized area of public school finance. AIMS does not propose any significant or institutional or organizational changes or a change in its fiscal agent, and has not called for the introduction of an alternative charter management organization to oversee its daily operations. AIMS has instituted a new handbook for board members and has undergone 3 or 4 board training sessions for its board members, but has instituted no significant overhaul in the procedures for board operation or for continuing board education and training. And lastly, the AIMS response has not addressed sufficiently the status of the school's relationship with its founder. The notice of violation asked AIMS to implement and identify remedies in 5 specific areas, and those are listed in the slide above. The notice of intent to revoke, it's based upon the conclusion that AIMS has not remedied the violations in any of those 5 areas. And now a word about procedure and due process. As General Counsel Minor has indicated, the revocation process, by its nature as a matter of law, involves granting AIMS as an institution due process rights to respond to the violations. In addition to the legal protections, the district has reached out to the organization a number of times during this process. First of which was in September of 2012, when the then director of the Office of Charter Schools met with 2 AIMS board members, including the president of the AIMS board and legal counsel, to present the notice of violation in person. And during that meeting, it was emphasized that the channels of communication between the 2 parties remained open with respect to the remedies that AIMS was proposing in response to the notice of violation. In September 2012, after the board's approval of the notice of violation and an open session board meeting, again, the director of the Office of Charter Schools at the time communicated with AIMS's counsel at the time that the district was open to communicating with AIMS during the 60-day remedy period and was open to having an open dialogue about AIMS's proposed remedies. AIMS did not initiate communication as a result of that conversation. And third, at the end of the 60-day remedy period, the Office of General Counsel of the district reached out to AIMS and invited AIMS to set up a meeting with AIMS's board members to discuss AIMS's response to the notice of violation. AIMS did not request a meeting in response to that overture. I'll now turn to a recent revision to the Education Code, which took effect January 1st of 2013. A new provision was added to the Education Code, specifically the revocation procedure, and that provision reads, "The authority that granted the charter shall consider increases in pupil academic achievement for all groups of pupils served by the charter school as the most important factor in determining whether to revoke a charter." AIMS's API scores, respectively, for AIPCS for 2012 is 974. For AIPCS 2, is 981, and for the American Indian High School is 928. This provision does not prohibit a board from revoking a charter with high academic achievement, but requires procedurally that the board consider the school's pupil progress in determining the ultimate question of whether to revoke a charter. Staff has considered AIMS's academic achievement in the course of recommending the notice of violation, and has also conducted a balance between AIMS's academic track record and its violations of law and fiscal mismanagement, and has concluded that, on balance, the violation of laws and fiscal mismanagement are sufficiently egregious to warrant proceeding with a notice of intent to revoke. I'll make some brief comments about the procedure. This is step 2 in a 3-step process. The first step occurred in November when you as a board approved the notice of violation. The next step tonight, we call the question of whether the board will approve a notice of intent to revoke. If the board does approve the notice of intent to revoke, there are further due process protections for the charter school. Within 30 days, a public hearing will be held in open session to gauge the level of public support and to receive public input on the issue of revocation. And by the end of March, the board will decide and make a final determination on revocation in an open session board meeting. If the board does revoke, the charter school has the option of appealing the final decision first to the County Board of Education and also next to the State Board of Education if necessary. That will conclude staff's prepared presentation.